This podcast is brought to you by the School of Advanced Study, University of London.
Typically, Pitt-Payne QC is known to most of you, I imagine, if not personally, then by name and reputation. He has specialized in almost all the aspects of information law, ranging from data protection to freedom of information, and all the way from the First-tier Tribunal to the Supreme Court. Most recently in the Prince Charles case, the notes to the ministries. And on a day when the European Court of Human Rights has decided that journalists have the right to use surreptitious cameras, I think does privacy or privacy matter is even more important.
Thank you very much for the kind introduction. I'm hugely flattered to be asked to speak today, and I'm absolutely delighted that this centre has been established. I think the idea of having a sort of hub where you try and bring together practitioners, academics, policymakers, anybody else with an interest in this area, I think that's a really excellent idea. And I think it's a fabulous area. I mean, takes one absolutely to the heart of so many important legal, social, technological, even philosophical debates. I got into this area really by accident. I'm sure people will have come across the concept of privacy by design. Well, I think there needs to be a balancing concept which I call privacy by accident. Because I tell you how I got into this area. My chambers does a lot of conference speaking collectively, and we were supposed to be fielding a team of speakers for a local government conference. This was in about 2000, and they wanted somebody to speak about data protection. Nobody was keen to pick this up, so I said, oh, what the hell, I'll mug it up. So I did, and I duly gave my presentation. And at the end of it, a solicitor from a public body came up to me and said, oh, thank heavens, I found somebody who knows about this area, and proceeded to send me a long set of instructions. And by the time I'd worked my way through that, I did know at least something about this area. So never ever trust the way that barristers market themselves. That's the first thing. Now, the title that I chose for this evening was Does Privacy Matter? And I chose that partly because I thought that was a really nice, broad title. It would give me an excuse to talk about a wide range of things that I'm interested in. And I started, when I look at my notes in front of me, the first subheading I see is what is privacy, which is a really terrifying subheading. And I'm not going to try and give any sort of an authoritative view on that, but really just to talk about the particular aspects of it that I want to focus on this evening. And it's really the aspects that are relevant from the point of view of the centre. It is, of course, a very, very wide-ranging concept, and that may be one reason that the common law has historically been suspicious of the idea of a right to privacy. Compare the common law's very gradual acceptance of the idea of some sort of a principle of unjust enrichment, and these are wide concepts. And I think the common law has been a little bit scared of them. It's notable when you look at Article 8 of the Convention that Article 8 doesn't talk about a right to privacy, it talks about a right to respect for private life. So you don't have a right to have a private life, you have a right to have it respected. And why is that? Well, possibly it's because of a legal recognition that it's not actually up to the courts or public authorities whether you have a private life, it's up to you. Singapore has a state-organised dating agency, but most countries, including the UK, don't have that. So you have to go out and find your private life, but the state has to respect it. The breadth of the concept of privacy, I think, is illustrated by some of the case law that we had under Article 8. For example, when there was the legal challenge to the legislation that was seeking to abolish fox hunting, when the Countryside Alliance brought that challenge, one of the things that they relied upon was Article 8, an interference with private life. I'm not talking about the whole area of privacy or private life. I'm talking about a specific aspect of it, which I would call information privacy and related ideas. That's about protection in relation to information about yourself, and specifically, but not only, particularly sensitive kinds of information. For example, information about your health is a classic example. So what we're talking about really is the individual's right to have some sort of control over the way in which that kind of information is collected or stored or used or disclosed. And I think related to that is the idea of the individual's right to be protected against intrusive or secretive means of information gathering. So certainly questions about surveillance are very closely related to questions about the privacy of information. And those two things really come together, particularly where you're looking at the collection of very large volumes of information and the use of that information to draw inferences about people. We used to talk about data valence. People don't talk so much about data valence now, but they talk about big data instead. So concerns about information, concerns about surveillance fit together very nicely. So here is an area where Article 8 of the European Convention tells us that we have a right at any rate to have it respected. But at the same time, I think there's quite a lot of skepticism. You hear quite a lot of skepticism about this idea of a right to respect for private life. Either on a kind of King Canute basis, that's to say, the forces that are undermining your private life are forces that we can't hold back. Or simply on a basis that, well, does it actually matter very much intrinsically? So I want to identify three sources of skepticism. One is the line of argument that says, in a famous quotation, I think it was from the chief executive of Sun Microsystems, "You have zero privacy anyway, get over it." And this is really an argument about the march of technology. We all leave an electronic trace from our online life, whether it's our online shopping with credit cards, whether it's the web pages that we visit, whether it's our use of social media. Out there is a tremendous infrastructure of CCTV cameras. If you put those together with facial recognition software, then that opens the door for a considerable amount of monitoring and surveillance. We have more and more discussion about the Internet of Things or the Internet of Objects. The idea that your fridge will be talking to the outside world to say that you're now out of milk. And by the way, you've been buying rather too much soft cheese and butter. It would be a good idea to cut down on that. And then you have the wearable fitness app, which tells you how many steps you've taken today and gives you encouraging messages about how it's sure that tomorrow will be better than today. So a set of technological methods to which we sign up, which we make voluntary use of, but which make it easier and easier to collect vast amounts of information about us. Then I think the second source of skepticism, and this is really a sociological argument, this is the young people don't care about privacy argument. And in terms of socio-legal areas that the centre might profitably look at, I think it would be really interesting to see some proper research done into young people's attitudes to privacy, particularly in relation to their online lives and their use of social media. I don't know if people are familiar with The Onion, that marvellous spoof American news website. Anybody who thinks that Americans don't have a sense of irony, don't have a sense of humour generally, should go and visit The Onion website. It is brilliant. And they had a lovely spoof news story about the 2040 US presidential election. And the story was, every potential candidate for the 2040 presidential election is already unelectable because of material that they posted on Facebook. So that is the young people don't care about their private lives argument. And then I think the third source of skepticism that you come across is the argument that a concern about privacy is a luxury, and often regarded as something of a selfish luxury, a concern of the middle classes, the North London middle classes, the chattering classes, call it what you will. So, for example, people will say it's a luxury compared with the importance of child protection. So where you try and balance privacy against child protection, the children should win, that's the argument. Or it's a luxury when you compare it with the imperative to protect national security and fight terrorism. And those are both arguments that you get from the political right, broadly speaking, but I think sometimes there's an argument that you get from the left, which is concern to protect your private information is a kind of selfish concern. It's hoarding your information. And I think you see this in relation particularly to health information, where you see it argued sometimes that really we should be willing to share our health information via the NHS because of the enormous clinical benefits that that could yield, and that you should be willing to give information in the social good, just as you would be willing perhaps say to give blood in the social good. So there are some sources of privacy skepticism, and they're commonplaces of public and media debate. And I think generally, if one's looking at areas for research in this area, and particularly the socio-legal research, very interesting to try and dig down behind those sceptical arguments and see how much substance there is to them. So, despite the skepticism, do we actually still care about privacy? Does it matter to us? Well, I think there's quite a lot of evidence that it does. And I think there's quite a lot of evidence in public debate that it does. If you think back to the last Labour government, the 2005 to 2010 Labour government, there was quite a lot of evidence in public debate that was going on during that period of a concern about privacy. And I would point to a couple of examples of that. One was the HMRC data loss in 2007, where the HMRC had apparently succeeded in losing the whole set of records for child benefit, something like 25 million individual records. And that was front page news, and that was huge. And it's not surprising that that was huge because of the concerns that that would be exposing people to the risk of identity theft. So that was a really concrete source of concern. And then, do you remember the concerns about some of the large public sector databases that were being built up at that point? Particularly the proposals in relation to those who were working with children or vulnerable adults. And the proposal that there should be a database that would track absolutely everybody who was involved in working in that field and would have their information in a single source. So all of that created a huge debate. And then I think in the current Parliament, under the coalition government, we've seen the debates around care data and the concerns that people have had about the use of their health information in the NHS, and particularly the extent to which it might be shared with private companies, including insurers, including pharmaceutical companies, the concerns about the use that might be made of it, and the concerns about whether their health information might be identifiable. And when you come across somebody who purports to be sceptical about whether there is any real value in privacy and whether we really care about it, I think a real way of testing that out is to say, well, how do you feel about your own medical records? And how would you feel if your GP put all of your medical notes on the internet for the world to see? And if the answer is, well, I wouldn't be comfortable with that, then at some level you do have a concern about your privacy, however much you might claim that it's a lost cause. There are some quite interesting diagnostic stories. I call them diagnostic stories because I think your response to them is quite a good illustration as to whether you think this area is an area that matters or not. And here is one of my favourite ones. This is a story from the US again. This is a story about Target, which is the second largest US discount retailer after Walmart. And this was a story that made the US media a couple of years ago, which started with an angry man going into his local Target store, demanding to talk to a manager and brandishing something that his daughter had been sent in the post that morning. He said, "Look, my daughter, she's still in high school. What have you been sending her? You've been sending her coupons for baby clothes and cribs. What on earth are you trying to do? Is your company trying to encourage my daughter to get pregnant?" And of course, the manager didn't know the backstory to this, but when he saw what his company had been sending through the post to this man's high school daughter, he was hugely apologetic. "Yes, I can see what we've been sending out. It's adverts for maternity clothing and nursery furniture and things like that. It's obviously inappropriate. I'm really sorry." And a few days later, the manager called the same man on the phone to apologise again. He met a rather different reaction. His customer was significantly less bullish than he had been in the previous conversation. Father said, "I've had a talk with my daughter, and it turns out that there's been some activities in my household that I hadn't been completely aware of, and her baby is due in August." So, Target knew that this girl was pregnant, if not before the girl did, then certainly at any rate before her father did. How did they do it? Well, it's actually a story about what is often referred to as big data. What Target did was they assigned every customer a guest ID number, and that enabled them to pull together all the information that they had about each of their individual customers. And then what they did is they analysed it in various ways. And one of the things they did was to take the women who'd signed up for their baby registries and then look at the information about those women's previous purchases. And what they were able to do was to identify about 25 different products. When you pulled those products together, you could assign each shopper a pregnancy prediction score. And not only could you assess the probability of them being pregnant, but you could assess the likely due date within a very small window, because what they found is that there were particular products that people tended to buy at particular stages of pregnancy. So that is how they did it. Now, this is a story about information that is in a sense public information. What is in your shopping basket on a particular occasion is not a secret in the sense that everybody who is there in the shop with you can see it. But when you aggregate that data and you put it as part of a very big database, you can draw all kinds of inferences. And looking at it with UK eyes, one of the things that you look at when you think of that story as a kind of data protection person, you say, well, what that store was doing was they found themselves processing what we would categorize as sensitive personal data. So they were running a program about shoppers. All of a sudden, they're processing sensitive personal data, data about the state of somebody's health. There are all sorts of specific conditions about how you process that. And obviously, if something like that was happening in the UK, you would be saying, well, on what basis can they justify processing this sensitive personal data about somebody's state of health? So that is, I think, quite a nice story about the way that information can be used in unexpected ways by a large organisation. But sometimes it's not a big organisation that is responsible for potentially violating somebody's privacy. Sometimes it's not the state or the large company. Sometimes it's us collectively. And another one of my diagnostic stories is a story about how we can collectively impinge on one another's right to respect for private life. This is a story from South Korea about 10 years back. This is a story about a woman who was travelling on an underground train in South Korea with her dog, one of those little lap dogs. And she refused to clean up after it when it relieved itself in the train. Those round her were not happy, and one of them actually took some pictures of the incident on a camera phone and posted them online. And they went viral. And she began to be known by an unflattering nickname, politely translated as Dog Poop Girl. And of course people were wanting to find out information about Dog Poop Girl. And not just about her, but about her parents and her relatives, her identity, her past. According to the news reports, she was so badly affected by all of this that she dropped out of university. And Daniel Solov, who's a George Washington professor and a major figure in this area, described this as an example of online citizens acting as a cyber posse, tracking down norm violators and branding them with digital scarlet letters. Nice description. Now, this was a piece of antisocial behaviour, and it's not surprising that those who were on the spot at the time were unhappy and made their feelings clear. And that's just part of living in society. But the fact that this story, this incident, was so widely spread, so that people were aware of it all around the world, that's the concern. Now, is this about private life? In one sense, not. It's about something that happens in a public place. Public transport is a public space. But the fact that information about what you do in that environment can be so widely spread, much more widely spread than we would historically have expected, I think means to me that there is an aspect in there about private life. And it's a concern about the way that social shaming can get out of hand as a result of things that happen online. There's this lovely 18th, 19th century idea of rough music. I think it turns up in the Mayor of Casterbridge. That the unpopular person in a village who behaves badly, everybody else in the village turns up outside their house and makes a load of noise with pots and pans and drums and whistles, and in effect drums them out of the village. Rough music. So what we have, the digital Scarlet Letter, I would call it digital rough music. And the trouble is, you're not just being drummed out of your local village, you're being drummed out of the global village. And where are you supposed to go then? But this is not something that you can readily address by regulating companies or public authorities, because that story is about people's collective behaviour. Now, it's an interesting issue. Does this story trouble you? Do you think there's a problem there? I told that story once at a lecture, at a student lecture, and somebody came up after me to talk to me, and he was actually from South Korea. And he said, look, his view was that that was a society that was very, very highly networked and digital and online. And his personal take was that story was nothing to worry about. That was simply what happened these days, and that was something that we all had to get used to. So, a couple of diagnostic stories there. Now, what about the law? What about the law bit of the piece? But what about the legal tools that we've got to deal with these emerging social and technological and political problems? Do those tools actually work? There's plenty of evidence that the law is taking the right to respect a private life very seriously indeed. And I think the strongest example of that in the UK is the introduction of the Human Rights Act and the greatly enhanced role that that has given to Article 8 of the European Convention and the right to respect for private life under that convention. And really what that's given is two things. First of all, it's given a weapon specifically against public authorities, a basis for controlling the way that public authorities use personal information, and something that sweeps away a lot of the technicalities associated with data protection when you're dealing with a public authority. And secondly, of course, it's given us a complete change in the way in which breach of confidence works. And what we've got is a new style claim for breach of confidence, otherwise known as the tort of misuse of private information, where the centre of gravity of breach of confidence has shifted. The centre of gravity used to be about protecting particular kinds of relationships, confidential relationships, information that you confided within a confidential relationship was protected. But now, the focus with the tort of misuse of private information, the nature of the information itself. Is this information that individuals would have a reasonable expectation that it will be kept private and not disseminated? So it doesn't matter if the person against whom you're claiming is somebody who saw you in the street and took a photograph of you, for example. There's potential protection there. Alongside our sparkly new, or relatively new, Post-Human Rights Act Article 8 rights, we've got data protection legislation, which goes back in this country to 1984, a rather iconic year. We had our first batch of data protection legislation in 1984, and then, of course, the current legislation in 1998. Now, potentially, we're looking at a new batch again, giving effect to the proposed general data protection regulation coming from Europe. I wanted to look at the Data Protection Act as it stands and just say a few things about how effective it is as a tool. Now, I suppose a threshold question is this about private life at all? Or is data protection something different? Because you certainly do see the argument made sometimes that really data protection is one thing and the protection of privacy is another, and the two are not necessarily identical. And it's true that there are some aspects of the Data Protection Act that are really going beyond a concern about private life. For example, the provisions about automated decision-making, in a sense, these are about general fairness in decision-making. And there have been cases, I think, where people have tried to use the Data Protection Act as a way of introducing public law, Wednesbury-style rationality standards into private sector decision-making. And I'm thinking of the Johnson and Medical Defence Union case as an example there, where there was an unsuccessful attempt to use data protection legislation in effect as a way of testing the rationality of a decision by an insurer as to whether a particular doctor should be given professional indemnity insurance or not. And the courts didn't accept that, and I think there's an underlying sense there that that was not what the legislation was for. I think there's a lot there in the Data Protection Act that really tells you that this is a piece of legislation about private life. That's what the preamble to the directive suggests, with its various references to Article 8. And I think it's what the content of the legislation suggests also. Because I think if it's not about the protection of privacy and private life, why is it that it focuses on personal data, data about ascertainable individuals? Why isn't it about fairness and transparency in relation to the processing of all kinds of data? So that focus on identifiable individuals, I think, really tells you we are in the territory here of private life. So approaching it on the footing that this is at the moment our key governing privacy statute, is it fit for purpose? Well, it's not a popular piece of legislation. Telling people that you are a data protection lawyer is not quite as bad as telling them that you're a health and safety lawyer, but it's kind of heading that way. It's not clearly drafted, and even the courts have complained about the drafting of the legislation. the key principles actually make quite good sense, but you have to hack your way through to the schedules before you actually find them. I think its application is made complex, perhaps unduly complex, by three key distinctions that are built into it. And I think there's a big question about whether we need those distinctions. One is the distinction about what is and isn't data. One is the distinction about data controllers versus data processors. And one is the distinction between regulated use and purely domestic use. In relation to the first, is it or isn't it data, I think this matters much less than it used to, because electronic data is now so ubiquitous. But in principle, there is a distinction between electronic records and paper records, with not all paper records being covered at any rate for all purposes. And there is a real question, I think, if we're looking at things through a private life angle, does that distinction actually make sense? Secondly, the distinction between who is a controller and who is a processor. And the idea of the legislation, the scheme of the legislation, is that you load a lot of duties onto controllers and you get them to police processors. And quite a lot of ink is spilt and quite a lot of thinking time is spent trying to work out whether, where you have two people who are involved with a database, who's the controller or who's the processor, or are they perhaps joint controllers or controllers in common? And I think there's a real question as to whether that is actually helpful, and whether we would be better, for example, just talking about people who hold personal data and imposing duties on them. And I think that third distinction between regulated use and purely domestic use, I think we are really quite confused about where we want to draw that line. And I say that particularly in relation to people's ordinary use of the internet and social media as part of their ordinary lives. If you go back to the Lindqvist case in the European Court of Justice, as it then was, 2003, if you remember the Swedish woman who had something called an internet homepage in the days before Facebook and in the days before blogging. And she put some information on there about one of her colleagues being off sick, and she fell foul of the local data protection authorities for processing sensitive personal data without compliance with the Swedish data protection legislation. And the European Court of Justice said, yes, absolutely right. And one of the things they said was you can't treat this as being private or domestic use, which is one of the exceptions, because it's visible to everybody, to the whole world online. Now, if you take the logic of that seriously, pretty much every teenager in the country, certainly everybody with a Facebook presence or social media presence, should be registering, should be notifying the Information Commissioner on that basis alone, should be thinking about the conditions that they fulfill when they process sensitive personal data about their friends. Needless to say, there has been little appetite from the Information Commissioner's office for enforcing the legislation in that way. Looking to the actual content of the Act, just a few comments about that. I think the right of subject access and the way that that works in practice is hugely problematic. The idea that you should be able to have access to your own personal data as a foundation for all of the other data protection rights, again, from the point of view of protecting private life, that makes good sense in principle. The problem is in practice, it can turn into a kind of unstructured but very onerous form of electronic disclosure outside the constraints that would apply in a civil litigation context. So for the conscientious data controller, which tends very often, though not always, to mean the public sector data controller, it is hugely onerous. But at the same time, the enforcement mechanisms are relatively weak, because for most individuals, if you really want to enforce your subject access right and you're unhappy with what's been done, you're looking at going to court as opposed to going to the specialist information tribunal. So all the cost, risk, and all the expense there. The right of individual compensation, I think that has been broken in the past. The reason I say it's been broken in the past is that historically, the courts in this country have taken the view that you, in virtually every case, you don't get a compensation claim off the ground unless you can show measurable financial loss. And again, from the perspective of protecting private life, that doesn't make much sense, because surely your right to respect for your private life is absolutely quintessentially the sort of thing that is not measured in monetary terms, is about things like distress rather than cold hard cash. We're moving away from this in more recent case law, and I think that opens up the possibilities for certainly group litigation in relation to things like major data security incidents, where a lot of people's private life is affected by a mass data security breach. So you might be saying, well, each of those affected individuals could have a claim for perhaps a few £1,000s for distress. Add it up together, it's worthwhile to have a law firm taking that on. Of course, we have a regulator, we have the Information Commissioner, and the Information Commissioner has a whole range of enforcement powers. And I think this is another area where I would identify a real area of potential research for the centre. It's the way that the Information Commissioner uses its powers in the context of data protection. Because I think there's an awful lot that we just don't know about that. Yes, if there is enforcement action taken, obviously we will know about that. If monetary penalties are issued, we will know about that. But the vast majority of the ICO's data protection casework ends up with an assessment of whether somebody is likely or unlikely to have complied with the Act. And that doesn't leave any very readily accessible public record. So if you look at their freedom of information work, every year we have hundreds and hundreds of FOI decision notices, which enable us to analyse in some detail what is the ICO's current thinking about a particular freedom of information exemption. I think in relation to the data protection side of their regulatory work, there is a big information gap. And I think it would be a hugely useful research project for somebody to try and get a better understanding of how they're actually using their powers. Of course, what we do know about is their use of their powers in relation to monetary penalty notices, that relatively new power that only came in on the back of the HMRC data disaster in 2007. We know they're issuing large monetary penalties, or as they're often colloquially referred to, large fines. They can be up to £500,000, so significant sums of money can be involved. So far they've mainly but not solely been directed to the public sector, and mainly but not solely they've been about information security breaches. I think there are some interesting questions about whether that is a good way of doing privacy enforcement. I think there are pluses and minuses. As against the private sector, a large monetary penalty at least means that a data protection breach is not costless. Against the public sector, well, the money doesn't stay with the ICO, it goes round back to the Treasury. So it's one pocket of the public sector taking money from another pocket, money going round in a circle. Is that actually sensible? An alternative approach would be to say, well, rather than fining, what we'll do is, rather than saying you are to pay a fine of £200,000, the alternative would be to say you are to spend £200,000 on a programme to improve your data protection compliance, and we, the ICO, will come in and help design it for you. That's some thoughts about the data protection legislation. But of course, a lot of the legal bit of protection of private life is done by claims brought under Article 8 or by claims brought under that new tort for the misuse of private information. And all of that has the pluses and minuses that we associate with high court litigation. High profile, standard setting, can involve looking at a particular set of facts in minute detail. On the other hand, risky for individuals, expensive, major costs, downsides, so certainly not the only thing that you would want to be relying upon. So we have a combination of a statute and case law. We have a role being played by the tribunal, by the courts, by the specialist regulator. We have quite a complicated system of actually enforcing and policing our right to respect for private life. We have a piecemeal system. And I think one of the interesting suggestions is that the Information Commissioner might be reinvented as a privacy commissioner, pulling together the functions of all the different regulators who have a concern with the right to respect for private life. So again, as an area potentially for the centre to look at from a research point of view, the regulatory architecture that we have in this country and how it compares with the architecture in other similar jurisdictions, for example in other common law jurisdictions, is a very interesting area. For example, is it a good idea that the same regulator should be looking at both issues about the right to respect for private life and at issues about freedom of information? But this is really where I want to finish. Some of the practical problems that we have, particularly with online information and the online dissemination of information, there's a real question as to whether they can actually be addressed by any legal remedy that we can come up with. And I'm thinking particularly with the widespread dissemination of information that we find objectionable online. There's been some discussion in the media of the subject of revenge porn, and that has now been criminalised. The situation where at the end of a relationship, one party posts online intimate photographs or intimate footage. And again, the risk is that they go viral and they're widely disseminated. And there's a strong case for criminalising that kind of conduct. But there's also a question, what do you do? How do you actually get that information back? How do you get it off the internet? And the closest we've come to addressing that is in the fascinating Google Spain right to be forgotten case, where the information there, it wasn't that kind of intimate or obscene information. It was the information that somebody had been foreclosed because of debts that he owed to a public authority. And that information was online on a newspaper website in Spain and accessible through a Google search. And what the individual succeeded in doing was getting a finding that the information should be taken out, should be blocked from Google's search results. So it's still there online, you can still find it on the newspaper website, but Google can't link to it on the basis of the so-called right to be forgotten, that the information was effectively outdated. There was no longer a good reason for Google to link to this information about an ordinary private individual. If they'd been linking to information about, say, a politician, that might well have been different, as the CGAU made clear. Now, that, I think, raises all sorts of questions. I think it's the closest we've got so far to actually trying to take the legal tools that we've got and use them to try and tackle concerns about the widespread dissemination of information on the internet. But it raises all sorts of practical problems. And one problem, just to finish with, is I think the information is still out there. Google may not be linking to it, but the information is still there. And the way that the right to be forgotten is being operated in practice is if you want to take advantage of it, you have to say to Google, I want you to take these particular sites off your search results when people go looking for information about me. Now that's different from saying, I don't want you to link to these photographs, or I don't want you to link to this video footage of me, or to this information about you. So if you have information, as in, for example, pornographic pictures example, if you have information that is jumping from site to site and just bouncing round and round the internet, a right to be forgotten is not going to be address that, unless you do something much more onerous to the search engines and say, look, you've not just got to take these particular sites off your search results, but you've got to take this information, these photographs, these pictures, these videos off your search results, wherever they might appear. So I think the overall conclusions I would draw are, first of all, I would say yes, our private life does still matter, despite the various sources of skepticism. The law thinks it matters, but has a rather piecemeal set of techniques for dealing with them. And one can make some quite a detailed critique of those tools and suggest how they could be better. But I think some of the things that really threaten our privacy, it is not easy to see how any legal tool would address them in a wholly satisfactory way. Thank you very much indeed.